Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, this is going to be a video predominantly for the hometown crowd, but really all of you should listen up because there's a message in here that I think would apply to all of you. We're going to talk about drunk driving. Why are we going to talk about drunk driving on Washington gun law? Well, number one, it's a very irresponsible and dangerous activity, one I encourage none of you to engage in. But the second thing is, and a lot of people don't know this in Washington state, if you have a couple of different run-ins with the law over drunk driving allegations, you in fact can get disarmed. Don't believe me? I'm going to connect all the statutory dots for you today. So today, let's spend a few minutes and let's talk about how drunk driving can get you disarmed in Washington state. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to us by the good folks over at the Sonoran Desert Institute. That's right, get ready to launch your career today through education. Get ready to just start arming yourself today with education, and most importantly, get ready to start defending the inalienable rights of millions of Americans nationwide, all through our most powerful act, which is, of course, education. Listen, the Sonoran Desert Institute has a program, certificate, or degree for just about anything that you may desire. So for more information, check them out in the description box below, or easier yet, just go ahead and visit them at sdi.edu. Okay, Washington, listen, on December 6th, I gave about a 20-minute presentation to a whole bunch of very, very talented DUI attorneys throughout the state of Washington to let them know that there is a ticking time bomb in the statutes, a piece of legislation that went into effect quite some time ago, and I do believe the judicial system is going to now catch up, and suddenly, and some of you are probably already in this category, you are going to get disarmed because of allegations of impaired driving. Now, a couple of caveats. Anyone that's gone back and looked at my resume knows that for a large chunk of my early defense career, I made all of my living defending those accused of impaired driving. So I completely understand this stuff backwards and forwards, and I understand that good people do stupid things and end up in this situation. Okay, that being said, I'm not condoning the activity whatsoever, okay, because I unfortunately had to represent people who had made the same mistake that a lot of people make, but have much more dire consequences when collisions occur and people are seriously injured or killed. I can assure you there is no winner in a case like that, no matter what the result is. So, for your own sake, your family's sake, your own sanity, your own financial security, I highly encourage you to find a designated driver during the holiday season. Now, here's what we're going to be doing. We're going to be taking a look at 3 statutes today. We'll link them up all down below in the description box so you can geek out on it for yourself. The first statute is RCW 9.41.040. This defines all the offenses that you can be convicted of in which you will lose your Second Amendment rights. Then we're going to talk about RCW 9.41.041, which actually defines and outlines how we can get our firearm rights back. And then we're going to take a look at a statute way over there in RCW 46.61, which is the Motor Vehicle Code, and that is RCW 46.61.5055. Every DUI attorney knows it backwards and forwards. It is the DUI sentencing statute. Now, these changes in law went into effect during the 2023 legislative session, and I did a couple of videos on it, and I thank the 17 people that actually watched those videos. But all of you were completely spun up, for good reason, about the assault weapon ban. So while all of you were completely geeking out and freaking out over the assault weapon ban videos, a lot of you didn't notice House Bill 1562, which radically changed how we not only take firearm rights from people, but also how they get restored. Now, what was added to RCW 9.41.040? Because that's the statute that outlines all the offenses that will disqualify you from Second Amendment rights. And you know, it has all the felonies and the domestic violence offenses and all the things that you would expect to see there. But House Bill 1562 also added this language: or any prior offense as defined in RCW 4661.5055 sub 14, if committed within 7 years of a conviction for any other prior offense under RCW 46.61.5055. And so as you can see, suddenly a second offense DUI conviction, second offense within 7 years, will be treated as if it is a Class C felony, even though it is still a gross misdemeanor. Now, here's the other thing. If you lose those rights, yes, you lose them for a minimum of 5 years. Can you petition then to have your rights back? No, because now we're going to take a look at RCW 9.41.041. That's the statute that outlines all the procedural mechanisms and requirements in order to restore your firearm rights. Now, if you look down there in the statute, you will see once again, prior offense is defined by RCW 4661.5055, which means it's being treated in that particular section of the statute as though you will have to wait 5 years. But that's 5 years from the date in which the court loses jurisdiction of the case. And if you look in other portions of RCW 46.61.5055, you will know that most DUI offenders, especially second-time offenders, if they're convicted of a DUI on the second offense, they will get 5 years of probation. So it's 5 years of probation and then 5 more years of being a good boy or good girl following the end of probation. You're looking at 10 years, Washington, before you can restore your firearm rights. Okay, but then some of you are going, all right, but it's not that big of a deal because my first offense got knocked down to a negligent driving. And then I did a deferred prosecution on my second offense, so it's all good. Or, yeah, I got convicted of one when I was a younger guy, but then I had a little bit more money when I had my second one, and I got a really good lawyer, and he got me a reckless driving on my second one, which is exactly the kind of guy I talked to today. So this comes with a real life story, because I had told all of those defense attorneys on December 6th, it's just a matter of time before one of your clients calls and says, you're not going to believe what just happened. What happened to this gentleman? Well, what happened is that he got a DUI about 6.5 years ago. He actually got convicted of that DUI. Then he gets a new DUI and he goes out and yes, he hires a good lawyer, and that lawyer pulls a little bit of magic. Maybe there were some evidentiary issues. I haven't reviewed the police reports, but he gets him a reckless driving on the second offense within 7 years, which is really, really good lawyering. At no point, though, was this gentleman ever told at the time of arraignment, told by his rather competent counsel, told by the judge at the time of sentencing or at the time of taking the plea, ever informed by the prosecutor? Nowhere at any time was he told that his Second Amendment rights were at stake if he was convicted of just about any offense as defined as a prior offense. And this is where they hook you, Washington, because if you take a look at RCW 46.61.5055 subsection 14, you see this. Now, I know you can't read it, and that's fine. It's there for illustrative purposes. But what it shows is that according to Washington law, there's 17 different ways that you can commit a prior offense. So if you were charged with a DUI and it got knocked down to a negligent driving or a reckless driving or a reckless endangerment, it still counts as a prior offense. If you got convicted of a minor DUI because you were under 21 but you were also under the legal limit, it counts as a prior offense. If you got convicted of a boating under the influence, under 79A.60.040, guess what? That too constitutes a prior offense. You did deferred prosecutions and you actually got your case successfully dismissed. Congratulations. It still counts as a prior offense. So the bottom line is, Washington, is that if you've already been to the DUI well once in your life, you cannot go there, especially if you, A, value your life and the safety of others, but equally important, if you value your Second Amendment rights. Because if you are pinched on any kind of offense, which constitutes a second offense as broadly defined by RCW 46.61.5055 subsection 14, you are going to be disarmed under RCW 9.41.040. Listen, we're going to put all the statutes down below so you guys can connect your dots for yourself. Listen real carefully. There's an easy way to avoid this. I did this for years. The best way to avoid a DUI is don't drive impaired. Listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, we want to hear all about it by you clicking on that link right there and letting us know. If you just want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.